Our final speaker of the day is Frank DeSantis, who's a partner at Thompson Hine in Ohio and the chair of the firm's Conflicts of Interest and Ethics Committee. Frank's a trial lawyer with experience in complex civil and business litigation, including experience litigating securities cases, construction tort litigation, products liability actions, class action suits, and school law. Frank has defended many asbestos personal injury and wrongful death cases. He's now the only person standing between you and your summer weekend and your hour and a half of ethics CLE with the ethical issues regarding disqualification of trial counsel. Please join me in welcoming Frank DeSantis.
Keep your family and don't cross the line. Thank you.
Thank you as always, Marshall. Great presentation, although I'm not sure what Steve Kraft means when he refers to the ego of a successful trial lawyer. That didn't make any sense to me. Our final speaker of the day is Frank DeSantis, who's a partner at Thompson Hine in Ohio and the chair of the firm's Conflicts of Interest and Ethics Committee. Frank's a trial lawyer with experience in complex civil and business litigation, including experience litigating securities cases, construction tort litigation, products liability actions, class action suits, and school law. Frank has defended many asbestos personal injury and wrongful death cases. He's now the only person standing between you and your summer weekend and your hour and a half of ethics CLE with the ethical issues regarding disqualification of trial counsel. Please join me in welcoming Frank DeSantis.
I now find that I'm the only hurdle between you and cocktails. Disqualification of trial counsel. Why is that relevant to this group? I think for a lot of reasons, but let me relate to you two stories that just appeared in the legal news in the last couple of weeks. First story, law firm disqualified from a large, complex litigation. At the time the firm was disqualified, the client owed $1.9 million. Client refuses to pay. Law firm sues the client. Client counterclaims not only for a declaratory judgment that it doesn't owe the 1.9, but for disgorgement of the $4 million it had paid up until that point. Second story, law firm disqualified from litigation. The client that moved to disqualify that firm sues the firm, seeking not disgorgement of current fees, but disgorgement of fees paid to that firm for the last 18 years. So I don't know the merits or the facts of either of those cases. What's my point? My point is that disqualification of trial counsel is a very controversial and emotional area. It's very dangerous for law firms and very costly and disruptive to its clients. So with time permitting, I'm going to touch briefly, if I can move these things, there you go, on the rationale for legitimate disqualification motions, why they're filed, how to avoid them, and what to do if one's filed against you. Now, I've been trying cases for 33 years, and for the last 10 years I've been ethics counsel for a firm of 350 to 400 lawyers with offices in several jurisdictions. When I first started practicing, I rarely saw a motion for disqualification. People would threaten them if the facts were appropriate, but hardly ever were any motions filed. As my career continued, I saw disqualification motions continue until now they're commonplace. I've spoken with several judges who have confirmed my view. They tell me that they've seen an incredible and dramatic increase in disqualification motions on their docket. All of those judges indicated to me that they thought the large percentage of those motions were tactical and not legitimate. My own firm has seen 5 disqualification motions in the last 9 months, only one of which was successful, and shockingly, I disagree with that result. There are also a lot of indications by commentators and courts that have surveyed the issue, and they find that the motions for disqualification have increased substantially. So what does that mean? Does that mean that lawyers today are becoming more unethical or ignoring the rules of ethics? Or does it mean that disqualification motions are more and more being used as a tactical effort to disrupt the opposing party's case? Well, I think it's a little bit of the former and a whole lot of the latter. What are the legitimate bases for disqualification motions? Essentially, it comes down to two principles. Confidentiality, the misuse of confidential information or the threat of it, and the breach of a lawyer's duty of loyalty. The first basis is pretty straightforward. If a lawyer obtains confidential information from a client through the course of a representation, it is improper for that lawyer to use that confidential information in a representation against that client in the future. That principle is embodied in Model Rule 1.9. I refer to the model rules. Most jurisdictions have adopted them in one form or another. The former client is the representation of the current client substantially related to the representation of the former client. Application of the breach of the duty of loyalty is a little bit more complex. These principles were generally developed at a time when the lawyer and the client had a singular and long-lasting relationship. In today's world of national and international law firms representing multinational corporations with many levels of affiliates, many of which are independent, and all of whom hire dozens and dozens of law firms, it's a little bit more complicated to apply the principles of confidentiality and duty of loyalty, and a little bit easier to manipulate them. So how does a good lawyer find themselves in a disqualification motion? Well, primarily it's a poor conflict process or a good conflict process that the lawyers misuse or ignore. Let me give you a couple of examples. A lawyer receives a call from an in-house counsel of a potential new client. The in-house counsel relates to the lawyer. They believe they're about to be sued by a major competitor, very big case, very important to them. They explain to this lawyer what the potential claims would be, what their defenses are, some of the facts that they believe will assist them, and then they ask the lawyer, can you help me? Of course. Let me run a quick conflict check and I'll get back to you. Excited, that lawyer goes to the partner next door and starts telling him about this great case he's going to have. Starts relating to him what the in-house counsel told him, and his partner blanches. You probably know where this is going. The partner recognizes that case because he already represents the competitor and has been working for the last 3 months on developing a big case against that particular company. They've drafted a complaint. They've lined up their witnesses. Several hundred thousands of dollars have been invested in working on the matter. Partner jumps up and says, wait, don't tell me anymore. Too late. Probably a legitimate disqualification motion is in order. Another example. Law firm represents a corporate client. Only one representation, the matter is over. Hoping to get more work from that corporate client, they don't send a letter describing that the matter is concluded. Several months later, another client comes in the door with a major piece of litigation against the first client. They examine the situation. They say, well, that first client's matter is over. They're a former client. This new matter isn't related to that other matter, so we can undertake it. They file a lawsuit. Shortly thereafter, the client raises his hand and says, hey, wait a minute, you're my lawyer. I didn't think that other matter was over. And they file a disqualification motion. If the lawyer or the law firm had sent the client a closing letter saying the matter is over, we're closing our file, that might not have held off the motion, particularly in today's tactical world. However, it would have been very strong evidence that the position taken by that firm was correct. And if the client had in fact believed that the matter was still ongoing, they would have or could have communicated that to the lawyer. Another example is corporate affiliations. There are a lot of disqualification motions based upon representations by lawyers of affiliates of their clients. Company represents a corporate client, a partner in another office wants to be adverse to a sister corporation that's doing business in another jurisdiction with separate management. Can they do that? Oftentimes it's done without an analysis, and that leads to a disqualification motion. The ABA has set out in an opinion what they call the unity of interest test, and if you analyze the situation beforehand, you can avoid disqualification motions. It's generally, more and more clients are asking any law firm that undertakes to represent them to consider all of their affiliates as a client. And if you do have that situation, one thing you want to make sure is you get all those affiliates in your conflict database so you don't have a misstart. So what are the practical effects of having a disqualification motion filed and successful? Well, obviously, as I mentioned in the beginning part, you stand a chance of disgorgement of fees. You oftentimes may need to defend that motion to disqualify on your own nickel, particularly if the client was unaware of any potential problems at the beginning. You can lose clients and obviously bad publicity. So how do you avoid disqualification motions? Well, obviously the best way is to have a good conflict database up front to make sure that the lawyers in your firm know what the conflict system is and why they need to use it. Make sure that all the lawyers in your firm understand that they cannot get too much information at the initial discussion with a potential client before they run a conflict check. The example that I gave is something I tell every new lawyer that comes into the firm. It's a good example, the dreaded D word, disgorgement. You want to make sure that you understand if there's any conflict before you have a conversation with a prospective new client. As I mentioned, prospective new clients are entitled to the same level of confidentiality as existing clients. It's in Model Rule 1.18. If you have an ethics counsel and there's any question about conflicts, you ought to run it by the ethics counsel. If you don't have ethics counsel, you ought to retain some lawyer with a good basis and experience in ethics. It would pay you to understand if there's a risk of disqualification at the front end as opposed to fighting it after it's been filed. Also, using ethical screens. Too lengthy of a conversation at this point, but there are a lot of ramifications with the timely use of ethical screens, and make sure that all of the requirements that are called for by courts nowadays are in place. So what is the course of action when you're faced with a disqualification motion? First, if you have a disqualification motion filed against you, I would recommend talking to ethics counsel or a lawyer with experience in ethics to determine if there's a good basis for that motion. If it's bogus, then you're fighting it is a lot more practical, and your client would be more willing to do it. Second, you should consider advising your client to get independent counsel on the decision of whether to fight a disqualification motion. Recognize when a disqualification motion is filed against you and you're making a decision about whether you should fight it or not, you're attempting to justify your own position. You have a conflict of interest, and it's safer for you to have outside counsel advise the client about whether that disqualification motion is justified and whether it should be fought. But what if there is a legitimate basis for the disqualification motion? What if there was a conflict of interest? Is that the end of the story? Should you lay down? Well, of course not. The courts now have a balancing test. The fact that an ethical violation has occurred does not automatically result in a disqualification. If you look at your rules of professional conduct, most of them have a provision, either in the preamble or in some of the rules, that says this ethical violation or ethical violations of these rules do not automatically result in a disqualification. They're not the basis for malpractice. Many of you know that. They can be evidence of it, and they can be a rationale upon which a court may ultimately conclude that there should be a disqualification. But most courts go through a balancing test, and in the words of one court, the competing considerations that are to be weighed, on the one hand, to maintain ethical standards in the legal profession and to avoid distortions in the substance and appearance of the trial, and on the other hand, to protect the litigant's freedom to select counsel of his choice. Caution is to be exercised against too readily granting disqualification motions, which are often interposed for tactical reasons. And it's the tactical reason that is most often cited in opposition to motions to disqualify. Now, in the last couple minutes of my discussion, I'd like to tell you why I don't believe that disqualification motions are really worth the time and cost to your client. At the level that most of us litigate, it is very unlikely that if you are able to disqualify the law firm that represents the opposing party, that opposing party is going to say, I don't have a lawyer, I might as well go home. They're going to hire another lawyer. And so at best, you've disrupted their defense or their prosecution of their case, and you've caused them to expend money to get a new lawyer up to speed. But you didn't really affect substantively the case. And the old adage, what goes around comes around. You may face the same ultimate motion to disqualify based only to disrupt your case or to cause your client cost. As a person that spends a great deal of time in ethics, my belief is that filing a motion simply to cause your opponent to spend money or to disrupt their case is on the borderline of appropriate conduct. Of course, the other reason not to do it is if you lose, then you've wasted your own client's time and money, and that's not going to be something that they'll be very happy about either. So that concludes my remarks. I greatly appreciate your time and attention.